How can we find out what bank accounts, vehicles, and retirement benefits exist and where the money went? In an estate case, the key is getting the right legal authority and building a paper trail. First, confirm whether an estate is already open and get the estate file from the court clerk in the proper county, because the file may already include an inventory or accounting that lists assets and shows transactions. If no one has been appointed yet, an heir usually needs to apply to be appointed as the estate's personal representative, also called the administrator, and obtain letters of administration. Those letters are what banks, credit unions, and retirement plan administrators typically require before they will share meaningful records. Once appointed, the administrator can request date of death balances, ownership documents, beneficiary confirmations, and transaction histories to identify what existed and what happened to it. For vehicles, the administrator can use title and registration records to confirm ownership and transfers. For retirement benefits, the administrator can contact the plan administrator to determine whether there was a named beneficiary and whether the benefit was paid outside the estate. That is important because many retirement accounts and some bank accounts pass by beneficiary designation or survivorship and never become probate assets, even though they existed at death. For probate assets, the administrator should collect funds into an estate bank account, document every deposit and payment, and then file the required inventory and later accountings so the court file shows where the probate money went. If a third party is holding estate property or records and will not cooperate, the administrator can ask the clerk to order that person to appear, be examined, and produce the assets or records through a proceeding to discover assets.